Well, let's go. Good morning. We continue today with item number 13. We have today the presentation by the Policy Department C of the study on cross-border enforcement of intellectual property rights in the EU. We have 4 experts. We'll start with Mr. Giancarlo Froscio, professor at Queen's University Belfast, formerly associate professor at the University of Strasbourg, CEIPI, and Ms. Natasha Mangal, PhD researcher, also at the CEIPI University of Strasbourg. And they will present the main findings of the study on cross-border enforcement of intellectual property rights in the EU. So we will start with them. They will have 10 minutes, and then we'll go to the presentation of the other experts, and then we'll open the floor to questions. So, Mr. Froscio or Ms. Mangal, I don't know who is going to be giving the presentation. Hello?
Hello?
Yes, Mr. Froscio, we can see you. You have 10 minutes, and I will let you know when you have 1 minute left.
Awesome. Good morning, everybody.
Mr. Froscio, we lost your connection. Could you please press on the speak button again?
Hello, everybody. Can you hear me?
Yes, we can hear you. Thank you.
Okay. Again, thank you for inviting us to briefly present the result of the study on cross-border enforcement of intellectual property rights in the EU that I co-authored with my colleagues Alexander Bulayenko, Anna Lorinovic, and Natasha Mangal, and was commissioned to CEIPI. First, let me take this opportunity for thanking the Policy Department, Citizen Rights and Constitutional Affairs, and in particular Mr. Giorgio Mussa for the excellent support given in drafting this study. I will provide you with a brief introduction on goals and methodology of the study and fundamental challenges that cross-border IP enforcement faces and prompted the commission of the study. Then I will leave the floor to my co-author Natasha Mangal for further analysis regarding inter alia findings and recommendation of the study. Next slide, please. As per its goals, the study is divided in 2 main parts in response to the primary objective of the review, which is meant to describe and discuss the present legal framework and provide then policy recommendations. On one side, the study broadly attempts to understand the current situation for cross-border IPR enforcement in the EU by studying the enforcement measure that currently exists and considering to this end a selection of member states' practices, and also by assessing how effective existing measures are. In particular, this study then answers this question by focusing on the state of copyright enforcement and the action undertaken against online intermediaries or online service providers. On the other side, the study provides a set of comprehensive policy recommendations for possibly fixing negative externalities and imbalances that the present state of cross-border enforcement of IP rights in the EU might bring about. Now, the scope of this policy recommendation will be discussed in more detail later by my colleague Natasha Mangal. For now, let me stress that policy intervention in the field struggles with the potential need or the policy option of implementing expedited procedures for better protecting intellectual property rights and properly balancing, on the other side, competing fundamental rights of European citizens. Now, in disentangling this conundrum, EU institutions must always be bound by the principle that EU citizens' fundamental rights deserve absolute protection, and stricter enforcement measures are viable policy option only if citizen fundamental rights are not restricted as a result of their implementation. Next slide, please. As per the methodology, the study was carried out in 3 overlapping phases throughout the project period. First, of course, the desk research provided initial basis for establishing a baseline of enforcement measures currently available in the EU. Then desk research was the driver of a written questionnaire we compiled. Then, to provide practical insights into the
Mr. Frosio, we have lost you again. Is he still connected?
Yes, he's still connected. He's back.
Hello? Can you hear me?
Yeah, but it got disconnected.
Okay.
You
Are we
can
now
continue
good?
now.
I was saying we sent out the written question and written responses were collected from stakeholders who also participated in the interview stage. In total, 14 interviews were conducted with stakeholders during the project period, which included legal specialists, national judges, representatives of right holder organizations in different creative sectors, and representatives of Internet user society and online intermediaries. Finally, the overall effectiveness of certain types of enforcement measures were analyzed by using a combination of legal academic research and, of course, practical knowledge gained by the consultation. Next slide, please. As per the fundamental challenges surrounding cross-border IP enforcement, with special emphasis on the enforcement of copyright and related rights in the online environment, the study highlights at least 3 key issues that make the situation for enforcing copyright and related rights in the online environment in the European Union particularly problematic. First, in the past 20 years, infringement have become widespread and ubiquitous. They became a truly cross-border issue.
Touching something or what? Why?
No, it's
Hello?
just this connection that is dropping.
Okay.
Hello?
Yes, we see you again, Mr.
Okay. I'm coming down to a conclusion. As an evidence of the ubiquity of infringement, we discuss in the study the Pirate Bay case, which had been initiated in 13 different member states. Second, the rapid speed and broad geographical scope of infringement contrasts with the slow pace and national scope of enforcement. In this regard, the constant development of new technological solutions that make possible to stream real-time infringing content online from multiple jurisdictions, especially live sports events, is a quintessential example of the challenges that the traditional enforcement mechanism must face. Third, there are obviously high societal costs of infringement, as European IP businesses are deprived of value by piracy infringing activities, but also cost of enforcement, because enforcement also implicates the potential limitation of competing fundamental rights, such as freedom of expression, freedom to access information, right to privacy, due process, and freedom to conduct a business, a remark multiple times both by the Court of Justice of the European Union and by the European Court of Human Rights. This is in fact the grand tension that online IP regulation and policymakers must address in the years to come. I give now the floor to my colleague Natasha Mangal, who will tell you a little bit more about findings and policy recommendation of this study. Thank you very much.
Thank you, Mr. Frosio.
Okay, thank you very much, Giancarlo. At this point, I would like to briefly highlight some of the key findings of the study. So structurally, we divided our study and our policy recommendations into 3 different categories: voluntary, administrative, and judicial measures. As far as our main findings overall, most of the enforcement options we considered for the study were characterized by their national scope and application. This situation is due to the national territorial scope of copyright and related rights. As such, to address an infringement which occurs in multiple member states, rights holders must pursue multiple separate actions in each member state. Furthermore, though progress has been made in terms of efficiency of technologies for identifying and blocking IPR infringements online, online enforcement measures still fail to prevent infringements 100% of the time. For example, an infringer can use mirror sites to evade the scope of a blocking order. Additionally, blocking orders can be overbroad in scope, limiting lawful access to content in some cases. A final observation from the study was that for some stakeholders, the speed of enforcement measures was of critical importance due to the nature of the content at stake. For example, some recent studies conducted by the EU IPO have focused on the difficulties faced by the sports broadcasting industry, which relies heavily on monetizing live or simultaneous broadcasts within a short time frame. Accordingly, an efficient system of enforcement for such industries would require a process of notification and takedown to occur within a narrow window of time. Next slide, please. In the study, we also focused on current means of administrative and judicial enforcement of copyright and related rights online. Here, I will briefly compare the relative advantages and disadvantages of administrative enforcement options versus judicial. First, currently, not all member states have specialized administrative authorities or procedures in place, but in recent years, the use and availability of administrative procedures has risen. One key benefit of going through an administrative authority to enforce one's rights is specialized expedited procedures for addressing online infringements occurring on a large scale. Administrative authorities are also better equipped to monitor how effectively enforcement is carried out. For example, one specific mandate from the newly founded ARCOM in France will be to prevent infringing content from reappearing online through the infringer's use of mirror sites. These advantages are partly in contrast to the unavailability of the same in judiciaries. Judicial authorities, usually the General National Court of a member state, may not have the same technical capacities or administrative efficiencies to handle high volumes of infringement complaints. Yet, according to stakeholders, although the use of judicial measures generally seemed more costly and involved a higher time commitment, the guarantees of due process and the use of judicial decision-making for clarifying and improving aspects of enforcement were viewed as advantages. Ultimately, while both of these enforcement measures have their value, both types of measures are severely limited in terms of their applicability across member state borders. In the interview stage of the study, stakeholders voiced that they had little to no experience with trying to apply an administrative order or judicial decision obtained in one member state to prevent the same infringement from occurring in another member state. Next slide, please. Following this observation, the aim of Part 6 of our study was to provide a real picture of the effects of current enforcement options on cross-border enforcement. The varying shades of blue in this map illustrate that stakeholders currently enforce their rights against the same infringing websites in an incomplete manner across EU member states, even though the same infringing activities by the same bad actors are at issue. We found that stakeholders will conduct a cost-benefit calculation when determining the jurisdictions they will launch a legal action in. We also found that given the choice between administrative or judicial measures in a member state where both options were present, the majority of stakeholders opted for the use of administrative measures more often. This may be due to perceptions of lower costs and the procedural efficiencies available for addressing these types of infringements. This point again reinforces one of our main findings of the study, namely that stakeholders have a positive outlook on the future development of administrative authorities and procedures among EU member states, and that we can expect increasing availability of administrative measures for enforcing rights among EU member states. Next slide. Moving on finally to our policy recommendations. From the analysis conducted, we determined many potential avenues of reform. We determined that each type of measure, voluntary, administrative, and judicial, could be improved to better assist stakeholders in cases of cross-border infringements. For example, voluntary measures in the EU could be expanded in scope to cover multiple or all EU member states. Indeed, most internet service providers in Europe are multinational companies which operate in multiple member states or across the EU, so it would be feasible to extend the reach of these voluntary arrangements past individual member states. Furthermore, enhancing cooperation between member states' authorities can potentially be achieved through the introduction of an EU-level body or form of exchange for enforcement practices. Regarding improving the judiciary, increasing cooperation can take the form of introducing mutual recognition of judgments or orders obtained in one member state. We also find that in certain cases of obvious infringements, introducing a fast-track or expedited procedure can be beneficial for stakeholders. And in the long term, of course, attempting to achieve a more fully harmonized EU copyright through the introduction of an EU copyright code or unitary copyright title can provide a lasting improvement to cross-border enforcement in the EU. Next slide. Thank you very much for your attention. I'll now turn the floor to my colleagues, Alexander Bulayenko and Anna Lavrinovich-Jurek, for a brief question and answer. Thank you.
Thank you. Mr. Bulayenko, we can see you whenever you're ready.
Yes, hello. Thank you very much. So yes, here with also with my colleague Anna Lavrinovich-Drevik. So we're here for your questions, answers, and any further proceedings.
So I understand the presentation is over, and now we'll be able to make your questions. Okay, let me introduce you first. Mr. Bulayenko is postdoctoral researcher, education and scientific coordinator at CEIP University of Strasbourg, and Ms. Anna Lavrinovich-Drevik is PhD researcher, also at the same university. So now we'll open the floor for questions. Ms. Walsman?
Ja, vielen Dank für die...
Thank you very much. Thank you very much for presenting that study. I think it's better if I speak without my mask. Strong enforcement of intellectual property rights is essential because we can have the very best system in the world, but it doesn't achieve anything if we don't actually enforce those rights. I found your presentation very interesting, as well as your study, and I'd like to ask you a question about that. If I've understood correctly, then you have been looking at intellectual property rights which are difficult to enforce. And it seems then that intellectual property in other areas is less difficult to enforce. You have also determined that cross-border enforcement of intellectual property is not often a problem. Can you tell me why you think that is a problem? Why that is happening? Then it seems that procedures haven't been started in many member states because their actors see judicial measures as being more expensive and difficult. Would it not be better if we had a unitary patent system? Would that not improve the situation? I'd also like to know what you think about the use of new technology to prevent intellectual property rights being infringed. Thank you.
Thank you very much. Let's put together 2-3 questions, and then we'll give the floor to the experts. Gilles, Mr. Le Breton.
Sorry, excuse me, just before interrupting, just with interpretation was...
No, excuse me, Mr. Bulayenko, we're going to put 3-4 questions, and then I'll give you the floor, okay?
Good.
Mr. Le Breton.
I'd also like to thank the people who have come to enlighten us today about intellectual property rights. It's very important. And I'd like to be sure that I have really understood the conclusions that were presented in the two types of solutions, we have administrative or judicial solutions. I've understood that the judicial ones are more efficient and seem to be preferable, and you recommend greater cooperation between, in an administrative perspective, between member states. But you also said that you looked at 13 different states, if I'm not mistaken. Now, I believe in the examples of best practice. In your opinion, among the states that you've looked at, which member state is the most effective in the protection of intellectual property rights online? Because maybe we can take inspiration from their model at the European level. Thank you.
Thank you very much, Mr. Leton. Mr. Voss.
Vielen Dank.
Thank you very much indeed, Chair. I'd just like to check whether our experts have interpretation. Now they all seem to have disappeared.
We have lost all of them right now. So.
No, sorry, they can hear us, but so they have interpretation.
Of the German language.
So I'm going to ask to the expert. Have you heard the question so far?
Yes, we heard the question in French. So,
okay, so
the first question in German, there was no interpretation.
Okay, so what we are going to do is repeat the question from Ms. Walsman, as there was no interpretation, and then I'll give you back the floor, Mr. Walsman. Could that work? Okay, so Ms. Walsman, will you mind to repeat?
May I interrupt? Sorry. Dear speakers, you cannot have interpretation if you're live, so please keep your speak button blue, not red. We cannot see you, cannot hear, then you have interpretation. If you take the floor, you don't have interpretation. Thank you.
So, Ms. Walsman, will you mind to repeat the question?
Yeah. Yes. I think it was the first question that wasn't interpreted, and that was the question about intellectual property rights being protected. It seems that from what we've seen in the study that these intellectual property rights are difficult to enforce, but other intellectual property rights seem to be less problematic in terms of enforcement. I wanted to know more about that. That was my first question. But you did get my other questions, didn't you?
I am afraid they haven't. I mean, yours is the only one that they didn't have interpretation. So if you want to do all of the questions you had on your first intervention, I'm sorry.
No worries. I'll start again from the beginning. And I do apologize, but that's what happens when we're working in these remote circumstances. I found your presentation and study very interesting because it was talking about enforcement, which is crucial. I will ask several questions about that. My first question was that in your presentation you were looking at enforcement of copyright, and it seemed that seemed to be difficult to enforce, whereas other types of intellectual property rights were not as difficult to enforce. Secondly, you saw in your study that it was only rarely a problem to have cross-border enforcement. Can you tell me why that's the case? Thirdly, can you tell me why stakeholders decided not to have cross-border proceedings in several member states at the time? Why did they see the costs as being a problem? Would it be better to have a unitary patent system? Would that not significantly improve the situation? My last question was about the use of new technologies to combat intellectual property right infringements. And then I also wanted to know about your study of intellectual property rights enforcement in non-EU countries. Perhaps now I can ask a question that I was going to ask later. Do you have any feelings about whether a Directive 2004/48 is still useful and can be used for these purposes? Thank you.
Thanks for repeating. And now, Mr. Voss.
Vielen Dank, Herr Vorsitzender.
Thank you very much, Chair. I hope that all of the participants are still there, because now we can't see them. There was the question of which stakeholders were selected here. You talked about sports broadcasters, video games, music. I wondered why you'd left out the film industry. Then I was wondering whether you thought it would make more sense to have a European network or some kind of European fast-track procedure which could then block platforms when there were difficult situations. It would be interesting to know whether you think we need some kind of system for copyright. At the moment, we just have a system of guidelines. Would it be better if we had a European system with a regulation, with more cross-border platforms and global digitalization? Would it make more sense to have a more uniform system in Europe? Then it wouldn't depend on the different traditional systems and ways of looking at this in individual member states. Then we could have a kind of copyright single market. Thank you.
Very much. There are many questions, so we are going to now open the floor to the experts to reply them, and then we'll continue with more questions from the members. So I don't know who is going to start replying these questions, if Mr. Bulajenko or Ms. Lorinovich-Drewek.
I could begin. Can you hear me well?
Yeah, go on.
Okay, very good. So I'll start with the first question here that I noted. Sorry for the problem with interpretation. I think we misunderstood on how it worked. So with the first question, with regard to the administrative procedures, whether they are more efficient. So what we did, so according to many stakeholders, they are rather looking for pragmatic solutions. So in essence, it's not really a question of principle for them, whether it's administrative or judicial, they're just trying to look for the solution that works. And currently, administrative solutions, very often they provide a more specialized response. They are faster. They have a higher capacity to process a higher number of requests. So we could observe that for these reasons, right holders use more administrative solutions than judicial. So that's the first observation. It's not really administrative judicial, it's the one that is more rapid, more efficient, more specialized. That's the perspective of right holders. Of course, some of civil society representatives, they have concerns about the due process. That unlike in a court proceeding, they do not feel to have the same possibilities to represent their interest and in the case of administrative procedures. That's another argument. With regard to the administrative procedures and best practices, so administrative procedures first, as my colleague said, Natasha Mangal, during the presentation, they do not exist in all member states. So in some member states, there are no administrative procedures at all. It's rather, for now, still in a minority of member states where there are administrative procedures in place. But these procedures, administrative procedures, increasingly often become a common solution that in more and more member states they adopt these solutions to help with the enforcement. So for now, it's around, I think, 7 or 8 member states, depending on the count. And of course, I think with regard to the cooperation, we have already cooperation amongst administrative authorities in the field of copyright in different sectors. We have it in the field of collective management, in some other fields, but there is no coordinated response with regard to enforcement against these authorities. So that was a reason for this recommendation for a sort of cooperation, a forum where these authorities could meet and exchange their practices. Some of these authorities are relatively new. So, for example, the French authorities, the new ARCOM, is relatively new. Of course, it inherits the practices of Adopi, gets also some powers from the CSA, from another authority, but it also gets some new powers. And I think for many of these authorities, also the legislative reform in Greece is relatively new. And these authorities, they can have exchanges, and there could be a European facilitation from them talking to each other and learning as well. So that's to this question. Then, with regard to the question on cross-border enforcement, whether there is a usefulness of having a cross-border mechanism, it's a field probably where there could be a really added value of Europe, of the European Union, in essence that national measures of member states are typically are limited to the borders of a single member state, whereas the infringing activities are cross-border. They occur across the EU, they occur worldwide. So there is certainly a big added value that none of the member states can do something that can be done at the European level. So that's for sure. And there is a big added value in these cross-border procedures. With regard to the stakeholders consulted, of course, the consulted stakeholders were consulted on their voluntary basis. So some stakeholders responded favorably to our request for an input, and some stakeholders didn't respond favorably to our input. And among the stakeholders that didn't respond favorably to our request for information were some representatives of film and broadcasting industry. Anna, would you like to say?
Yes, thank you. I would like to answer the questions regarding the enforcement of intellectual property rights in general. So, indeed, as Mrs. Walsman said, there is a difference in the protection between industrial property rights and copyrights. And this difference is kind of highlighted in the cross-border enforcement, from the cross-border enforcement perspective. So for the industrial property rights in general, and with the upcoming unitary patent court, the enforcement is, cross-border enforcement is facilitated because of the presence of the unitary title. So, which means that the trademark owner or in the future unitary patent holder can seize one jurisdiction, which will have a power to issue, for instance, a cross-border injunctions, which will cover all the EU member states. In copyright, the situation is a little bit different because in copyrights we are applying the general European Union rules based on the Brussels recast regulation. So these rules exist. It is possible to have cross-border judgments. Nevertheless, the problem that we face is linked to this online environment and this ubiquitous infringement. So there is a possibility to have cross-border decisions if the right holder choose the jurisdiction of the defendant domicile. The problem with copyright infringement in online environment is that this defendant domicile is often very hard to define, which makes this possibility of having cross-border judgments very limited. Which means that the copyright owners need to prefer to seize multiple jurisdictions to obtain injunctive relief. And the problem of this multiple litigation strategy, which is linked to this online environment infringement, is that it raises a huge cost regarding the translation, regarding the evidence, because because copyright owners need to provide evidence in each country, in each member state where they are intending the legal action. Then they need to have a legal assistant of this member state. So regarding these costs, right holders prefer to choose one or two member states instead of choosing all the member states where they can identify the infringement. There is also you ask also a question of the unitary patent. So as regards to the patent law, it's true that nowadays we have the similar litigation system to the copyright one. So in the patent matters, we are applying the general EU rules. So the Brussels recast regulation. But in the future, so right now the unitary patent is already in the preparatory phase. So in the future we will have the unitary title with the single jurisdiction, which will be able to issue a cross-border judgment in patent matter with regards to the unitary patents, but also in the long term as regards to the European patents. And also, I just wanted to mention that that in our research, our research was kind of limited to the European Union member states because we really wanted to see the current measures that are administrative or the European Union law, which provides for harmonization. So it's true that as regards to the non-EU countries, this cross-border enforcement it's a lot harder because we don't have all of this harmonization instrument. It is true that we have some experts working on this. So there are international IP experts group that are working on this cross-border enforcement issues at the international level. But as such, right now, it's true that we don't have like this comparable to the European Union harmonization measures in the international level.
Just to complete also our response to the questions, I see also noted here a question on new technologies. So with regard to the use of new technologies, there is this question of efficiency. It's a very common question of whether the measures, technical measures adopted, for example, to block access to infringing websites are effective. So there is this question. Some of these measures, they do not give 100% result, so they can be circumvented, as also was said during the presentation. But it's being considered in the current practice that the dissuasive effect, there is still in practice, we can see an effect of decreased use of infringing websites. That an average citizen that cannot get to a website through a search engine, that cannot get to a website through a usual, normal, everyday use of a web browser is discouraged going to this type of websites. It is enough for an ordinary citizen. So that's with regard to the new technologies. They do not give 100% result, but they still give a tangible result for the practice of everyday access to infringing websites.
Thank you very much. I'm going to open again the floor for more questions. So I need you both, please, to press again the speak button so you can have translation. Thank you. Mr. García Blanco.
Si quisiera, en primer lugar.
Yes, I wanted to first of all thank the authors of the report. I think they have really done some excellent work. A lot of time and effort has clearly gone into this, so we really do appreciate that. I would like to follow up on some of the questions that my colleagues have already made. Very interesting questions, and I also had some thoughts here as well. So on the issue of harmonization, for example, which was touched on as being potentially useful, and I think that's something I would agree with. I wonder what your opinion is with regards to effective harmonization through the effective implementation of the copyright directive. So the situation before the directive was very different in the member states. So I don't know if you can observe something from the implementation in the member states. Do we appear to be moving closer, at least, to the beginnings of harmonization within the internal market, at least? I would also like to ask if, with regards to what's been approved or adopted rather up to now by Parliament with the Digital Services Act, if anything there you think could be a step back when it comes to tackling these online infringements of intellectual property. So I don't know if there's anything you've observed there that could be problematic. And then I was going to ask you about those member states who have administrative procedures in place, and you said that was 7 to 8 member states. Spain is looking at putting in place a specific intellectual property office to have a bit more flexibility in terms of those administrative procedures. I think this is something that's of an extremely high priority. There are infringements that if they aren't dealt with in a very short time frame, then the damages are already done and can't be resolved. In any case, those are my questions. Thank you very much.
Questions from the floor? No? So I'll give now the floor back to Mr. Bulajenko and Ms. Mangal, I believe. No, Ms. Lorinovich-Drewek.
Okay, first, with regard to the implementation of the Copyright Directive, and I imagine that you referred to Copyright Directive 2019, the study did not specifically focus on this directive, but we did look at some of the effects of the directive indirectly. So I think some of the effects could be seen on the side also of voluntary measures, some of the voluntary arrangements among the stakeholders, but we didn't go beyond that. Of course, the directive creates some momentum for some changes in the field of enforcement, but it mostly dealt with content filtering, so where you have something hosted on platforms or video platforms. In our study, we looked more into the question of websites, which would be rogue websites, pirated websites, which appear and that have just all their content there, not videos or third-party content hosted by content providers. So there's just a little limitation of our study, of the mandate that we had. Then with regard to the experience, you referred to the Spanish experience on blocking. So that's also an important measure here with regard to live events. So live events, the particularity of live events is that the value of a live event is linked to a very specific time period, 60 minutes or 1 hour of a football match or a concert or another event. So there's a specific issue where stakeholders experienced certain problems. And then, of course, in some of the member states, you can see now development of these new solutions with regard to the live blocking. You have it in Ireland, in some member states. In Greece, yes, Anna?
Yes, I have nothing to add to this point.
Giancarlo, would you like to add on Digital Services Act?
Hello? Yep. I could just add, I think there was a question that was wondering whether, I suppose that the references to the new directive and the Article 17 was whether that article as promoting harmonization or not, at least whether the final implementation is promoting harmonization. Now, as a matter of fact, this might be a challenge because we've been seeing, although this is not the direct focus of our report, but we've been seeing different implementation of the Article 17 by member states. Hence, the answer could be perhaps not. Perhaps in terms of harmonization, we might have an open issue for the implementation of the Article 17. As per the new regulation, my understanding is that the new regulation is doing a good job at stressing a key point in my view, in the view of all us writing the report, that any type of measures that are going to be implemented, which might be necessary, which it might be necessary to expand the scope of the measures, but they must be implemented.
We have missed you, Mr. Froese.
I was concluding, as long as they should be implemented according to the new regulation, as long as these measures are compliant with the fundamental rights framework. At least we can extract from the gist, from the general points made in the regulation, that fundamental rights are always to be taken into consideration when it comes to online enforcement. This is what I think I might say about these 2 points.
Thank you very much. If there is nothing else to add, I want to thank all the experts present here today, and thank you also for the study that I'm sure that it will help the work of this committee. So thank you very much. Well, now we get to the end of the meeting. Just to announce that the next committee meeting will be held in Brussels on February 10th from 9 to 11, as 11 will have coordinators, and then from 16:45 to 18:45. Thank you very much. Have a nice weekend.